So, what happens if you break the law, but it wasn't really your fault? Today, we're going to dive into this fascinating legal idea of excuse defenses. These are situations where, yeah, you did something wrong, but the law says you shouldn't actually be held responsible for it. Let's get into it.
Okay, so the facts might be totally clear. A law was broken. Simple, right? Well, not always. The story doesn't just end there. What if there was some kind of immense pressure, or a genuine misunderstanding? Or what if you were even set up by the authorities? This, right here, is where the law gets really interesting.
First things first, we need to get one really important thing straight. Not all legal defenses are created equal, and understanding this difference is honestly fundamental to everything we're talking about today.
So what you're seeing here are the two big categories of defenses. On one side, you've got a justification, like self-defense. That's where the law is basically saying you did the right thing under the circumstances. But on the other side, you have an excuse. Here, the law agrees the act was wrong, but it says you, the person who did it, shouldn't be blamed. It's really the difference between saying, good job, and we get it, we understand.
All right, so what does an excuse defense actually look like in a real case? Let's start with the classic example, being literally forced to commit a crime.
This is what you might call the gun-to-the-head defense. In legal terms, it's called duress. It's all about a threat of serious harm that's just so overwhelming it completely hijacks your free will. You're not really choosing to commit a crime, you're being forced into it. You might have heard about this in the famous Patty Hearst bank robbery case, where this was argued, though in her case, it didn't work.
But look, you can't just walk into court and say, someone made me do it. The courts have this super strict 4-part test you gotta meet. The threat has to be of serious, immediate harm, like right now. You have to believe it, and a normal, reasonable person would have to believe it too. And crucially, if there was any safe way out, any chance to run or call for help, this defense is pretty much off the table.
And this quote from a real case, man, it just nails the point. A vague threat that, something bad might happen to you down the road, that's not going to cut it. The law demands what it calls coercive immediacy. The danger has to be right there, in your face, leaving you with absolutely no other choice.
But here's the huge exception, and it's a big one. Duress is almost never a defense for murder. What the law is basically saying is that you can't choose to take an innocent person's life to save your own. It's a very clear moral line in the sand.
All right, let's switch gears a bit. We're going to pivot to a totally different kind of excuse. One that happens not because of a threat, but because of a complete and total misunderstanding. Okay, so to really get how these mistake defenses work, we first have to talk about something called intent. For some crimes, like theft, you need what's called specific intent. You have to actually intend to permanently take the thing from its owner. But for other crimes, like battery, you just need general intent. You just had to intend to do the physical act, like throwing the punch. And this difference, it is absolutely critical.
And here's exactly why that all matters. The law treats two kinds of mistakes very, very differently. If you make a mistake about a fact, like let's say you grab a suitcase off the carousel that you honestly, truly believe is yours, that can be a defense. But making a mistake about what the law itself says, oh, that is a much, much harder argument to win.
I mean, we've all heard this saying, right? Ignorance of the law is no excuse. And there's a really good reason for it. Think about it. If people could get out of trouble just by saying, oh, I didn't know that was illegal, the whole legal system could just fall apart. So the system works on the idea that we're all expected to know the law. Now, of course, there are a few exceptions, but they are incredibly rare. Like if an attorney general or a judge gave you an official statement about the law that turned out to be wrong, you might have a defense. Or in the super unlikely case a law wasn't even published where you could find it, you can't be expected to follow it. But yeah, the bar for these is just incredibly high.
Okay, for our last section, let's get into a couple of really unique defenses that pop up when things get a little weird, like when the government itself sets a trap, or when the crime you're trying to pull off is literally impossible.
Entrapment is all about when the police go too far, but different places have different ways of figuring this out. Most states use the subjective test, which focuses on you, the defendant. The question is, were you an unwary innocent who was lured into this, or were you basically just predisposed and waiting for the chance? But a few states use the objective test. They don't care about your predisposition. They ask, was the police conduct so over the top that it would tempt even a normal, law-abiding person?
Now, this next one can get a little tricky, so let's break it down. Factual impossibility. That's when you try to commit a crime but you fail because of some fact you didn't know, like trying to pick an empty pocket. That is not a defense. You're still guilty of attempting the crime. But legal impossibility, that is a defense. That's when you do exactly what you set out to do, but it turns out the act wasn't illegal at all, like buying goods you think are stolen, but they'd already been recovered by the police. There's no crime there to even attempt.
So let's pull this all together. Here's kind of the mental checklist you can run through. Was there duress, that imminent threat with no way out? Was there a mistake of fact that canceled out the criminal intent? Or was it entrapment, with the government going too far? Each of these questions gets us closer to figuring out if someone who did something wrong should actually be blamed for it.
And really, all of these defenses bring us to this one huge, fundamental question. How do we, as a society, balance holding people accountable for what they do, while also recognizing that sometimes a person's ability to choose is truly and seriously compromised? There are no easy answers here, and it's a challenge our legal system grapples with every single day. Thanks for digging into this with me.